Hi everyone, and welcome to my vlog on the EU-UK Trade and Cooperation Agreement and what it means for IP. Most viewers will be aware that on Christmas Eve in 2020, the UK and the EU finally agreed a trade deal. Now this deal is called the EU-UK Trade and Cooperation Agreement, or TCA for short, and it came into force when the Brexit transition period ended on New Year's Eve in 2020. In today's vlog, I'm going to give a brief overview as to what the TCA means for intellectual property, and in particular looking at copyright, trademarks and designs. To start with, I'm just going to give you a quick overview of some of the general provisions of the TCA, such as the objectives and scope, to help put into context the effect on IP going forward. One of the objectives is stated to be to ensure an adequate and effective level of protection and enforcement of IP rights. The scope is stated to complement and further specify the rights and obligations of the EU and UK under the TRIPS agreement and other IP international treaties. The international agreements section highlights that the parties affirm their commitment to comply with the various international agreements listed, and those include agreements such as TRIPS, the Rome Convention, the Berne Convention, the WIPO Copyright Treaty and the Marrakesh Treaty, amongst others. Just to give a brief overview, the TCA deals with bigger picture issues around the protection of IP rights in the UK and the EU. The intellectual property provisions of the TCA are mostly concerned with setting out the minimum standards and principles of IP protection and enforcement to which the EU and UK will remain committed. There is also some room for manoeuvre under the TCA, so the Prime Minister, Boris Johnson, explains in the summary explainer of the TCA that the agreement also retains regulatory flexibility for each party, enabling the UK to develop an IP system in line with our domestic priorities. The arrangements that flowed from the IP provisions of the earlier withdrawal agreement and the consequential UK exit regulations still remain in place and are generally of much greater significance than the higher level principles which are set out in the TCA. So really the agreements that came before the TCA tend to contain a lot more detail on the practicalities of the impact of Brexit on IP rights. Okay, so now I'm going to take a look at the impact of the TCA on the different rights in question, so copyright, trademarks and designs in turn. Starting with copyright. The copyright provisions of the TCA simply implement existing copying law and set out the general standards and mutual recognition between the parties on the protection of copyright. Any special rules or cross-border copyright arrangements that are unique to the EU do not feature in the TCA, and this is because they no longer apply to the UK. And the impact of these is dealt with in various statutory instruments and guidance notes published by the UK IPO. So just to give an example here, the TCA doesn't mention database rights, but database rights do feature in the earlier withdrawal agreement, and the UK legislation has already been amended to provide a new UK-specific database right, which is only applicable to UK citizens, residents and businesses. It's also worth noting that there's also an interesting provision under the design section of the TCA regarding the relationship between unregistered designs and copyright. This provision requires that the parties ensure that designs are eligible for copyright protection as well as design protection, and the parties have the freedom to determine the conditions for that protection, including the level of originality required. So I think this is potentially quite good news for designers, and if the parties are free to determine the conditions for protection, then this is an area where we may see the UK law starting to diverge from EU law fairly quickly. Okay, so turning to trademarks. The arrangements that flowed from the IP provisions of the earlier withdrawal agreement and the consequential UK exit regulations, things like the creation of comparable UK trademarks, these all still remain in place. And just to give you a quick recap on those things, since 1st of January this year, European trademarks, or EUTMs, no longer cover the UK. At the beginning of this year, the UK IPO converted approximately 1.4 million registered EUTMs to comparable UK trademarks. Any applicants for EUTMs which were still pending at the end of the transition period are now within the 9-month period in which they can apply for comparable UK trademarks and take advantage of the same filing, priority and seniority dates as the original EUTM. So much of the content of the TCA in respect of trademarks actually reflects the provisions in the Trademarks Directive, and that's things like the criteria and procedure for registration, infringement, defences to infringement and revocation. Buried in some of the details of the TCA, we noticed a number of differences, and perhaps these give us a bit of an indication that the UK might take a step back in the future in relation to some aspects of trademark protection. So just to give an example, there are no express provisions in the agreement retaining the existing rules on the dilution of trademarks with a reputation. And instead, the TCA relies on the application of the Paris Convention provisions on the protection of well-known marks. Turning to designs, design law in the UK is already quite a complex area, and it has various different overlapping and interlocking forms of protection. The position for registered community designs is aligned with the situation for EUTMs, which I have just described. So from the 1st of January this year, all registered and published registered community designs, or RCDs, will be given comparable UK design rights, and these will be recorded in the UK register. Applicants for RCDs that hadn't reached registration by the end of the transition period will again have the 9-month period to apply for UK registered design rights, taking advantage of the same filing and priority dates as the original RCD. Now, the position in relation to unregistered designs is slightly more complicated. The UK had proposed a system for continued reciprocal protection from the 1st of January 2021, and that meant that the disclosure in either the UK or the EU would give rise to both unregistered community designs, or UCDs, and the newly created comparable UK right. However, this proposal was rejected by the European Commission during negotiations in October last year, and so as a result the TCA itself contains no reciprocal provisions. The result of this is that designers will now have to choose between either disclosing in the UK and getting a UK-wide right only, or disclosing in the EU and getting an EU-wide UCD. I just wanted to give a brief mention to exhaustion of rights. The TCA expressly states that it does not affect the freedom of the EU and the UK to determine whether and under what conditions the exhaustion of IP rights applies. So the UK has effectively obtained the ability to set its own permanent regime for exhaustion of rights, and I understand that the UK IPO is going to be consulting on this issue in the next couple of months, so I guess the message here is to watch this space. Just to quickly mention border enforcement and customs. As the UK is no longer part of the EU Customs Union, EU customs authorities no longer enforce UK IP rights at their respective borders, and since January the 1st this year, IP owners will need to file separate EU and UK applications for action with the customs in the relevant territories. And so just to wrap things up, in conclusion, from an IP perspective, the TCA does not really do much more than set minimum standards which are consistent with current IP laws and systems already in the UK and EU, and it doesn't alter the arrangements which were set out in the withdrawal agreement, which the UK exit regulations and guidance notes issued by the UK IPO put into practice, and which will continue to evolve as the UK and EU enter into this brave new Brexit world. The TCA sets out the current status quo between the UK and EU concerning the different IP rights, but at the same time it leaves some room for flexibility for each party. And I think that the upshot of this is that it will enable the UK to develop an IP system which accords with our domestic priorities, as Boris Johnson said, and I guess we'll have to a certain extent, wait and see how far the UK will decide to diverge from EU IP laws and systems, which we've been tied to for such a long time.